Good evening, this is Left, Right and Centre. I'm Nidhi Razdan. The big story today, a huge blow to the centre with the Uttarakhand High Court striking down President's rule in the state, saying it should have been a last resort. As the court orders a new floor test for Harish Rawat on the 29th, was Article 356 misused by the centre? That's our big debate. Celebrations for Harish Rawat now reinstated as the Uttarakhand Chief Minister as the High Court sets aside the President's rule in the state imposed on the 27th of March, a day before the floor test was scheduled. Now the court has ordered the floor test on the 29th of April.
केंद्र सरकार से मैं विशेष तौर पर कहना चाहूंगा कि अब भी वो राज्य के साथ सहयोग करें तो हम इन घावों को कुछ सीमा तक, क्योंकि उत्तराखंड ने पहले भी बहुत सारे घाव खाए हैं, हमने समय के साथ उन घावों को भूलने का काम किया है, हम इनको भी भूलने का प्रयास करेंगे.
Congress party is proud of Indian democracy and the judicial system. Never before has there been such a blatant interference both in the governor's direction to have a floor test on 28th and in the Speaker's order of disqualification.
In its order, the court said President's rule should be used as a matter of last resort. Uprooting a democratically elected government introduces chaos. Any illegal interference affects the lives of the common man. The court also told the centre you can do this in every state, impose President's rule, then ask someone else to take oath. More than angry, we are pained that you are behaving like this. How can the nation's highest authority, the government, behave like this? The centre, though, ruled out that the court order was an embarrassment.
This is not a question of embarrassment. The central government has only reacted and acted on the basis of the recommendations of the governor and on the basis of the ground situation.
The government discussed its options, including challenging the order in the Supreme Court at a meeting at Amit Shah's house. The meeting was attended by senior leaders including Rajnath Singh, Arun Jaitley and senior lawyer Harish Salve. In Uttarakhand, meanwhile, both parties are confident of winning the floor test.
वर्तमान हरीश रावत जी जो मुख्यमंत्री थे वो कल भी अल्पमत में थे, आज भी अल्पमत में हैं. 29 तारीख को फ्लोर टेस्ट में सिद्ध हो जाएगा.
Both the political and the legal battle is far from here. The legal battle from here goes to the Supreme Court, and the political battle will now play out in Dehradun and Delhi. And of course, a lot will depend on what the Supreme Court says if the BJP challenges this order. But for the moment, in this match, round one has gone to the Congress. With Tanima Biswas in Dehradun, in Nainital with camera person Fahad, Shudhiranjan Sen for NDTV. Well, that really is the big story today. The former Additional Solicitor General of India, Raja Ramachandran, here in the studio with us. Shekhar Gupta joins us as well tonight. We'll be going across to the rest of our panel shortly. But Raja Ramachandran, very, very strong observations from the High Court through all the hearings that we have seen on this case, especially in the last few days. And this order, I think many people expected it would actually be reserved, and it came pretty quickly today.
Well, the central government forced the pace. This is perhaps the first time that the central government told the court that, sorry, we can't maintain the status quo till you give the judgment. Your judgment can be preempted. It was implied that maybe we'll revoke President's rule, maybe we'll install another government which will then have a trial of strength and your petition will become infructuous. And so the court rose to the challenge and said, all right, we've heard arguments. Normally, we would have liked to reserve judgment for some time for careful consideration, but if this is the stand you're taking, here's the judgment. And this judgment is significant for two other reasons. One, it affirms constitutionalism and the principle of judicial review, and it reasserts the independence of the judiciary, both of which are very, very heartwarming.
I'll take this, what you just said, to the former Attorney General Soli Sorabji, who joins us on the program as well tonight. Mr. Sorabji, Raja Ramachandran is saying that today's order is very significant for two reasons: affirming the principles of constitutionalism in the country, as well as reaffirming the independence of the judiciary. Do you see it that way, Mr. Sorabji?
Was there any doubt about the independence of the judiciary? I had no doubt. The judiciary may decide one way or the other, depending on the facts before it. And the question is, it's not the last word what the Uttarakhand High Court has said. The matter will be taken to the Supreme Court and we'll see how far the High Court's reasoning is correct. What's the basis for its interference? That all will be seen. So it's really not the end of the matter, it's not the end of the day.
But Mr. Sarabji,
sure
based on the reasons the High Court has given through its observations that an elected government was being undermined, that the centre had used haste in imposing central rule in Article 356, that even the president can go terribly wrong. Now, this is just what the High Court has said. Do you believe that is something that holds up according to you?
Yeah. No. President can be wrong. President is what the central government can be wrong. President means the central government. But the question is, Nidhi, this will all have to be examined higher. I haven't got the judgment of the court. I can't really say exactly where it went wrong. The question, one thing is certain. The court has jurisdiction to inquire into imposition of President's rule. President's rule is not beyond judicial review. I don't think there can be doubt about that. Whether he has exercised the power of judicial review on proper grounds, on grounds which are really related to imposition. You see, condition precedent to imposing President's rule is breakdown of constitutional machinery, constitutional impasse. Now, did the High Court find that there is no such thing? I find it difficult to really comment on it with any definiteness in the absence of reading the judgment.
That's a fair point, but and before I open this up to the politicians on the panel and Abhishek Singhvi, who will be joining us shortly, Shekhar Gupta, your assessment of what this judgment means politically for the government of India?
Well, it's a sizable setback because the BJP government had launched this campaign for Congress-mukt Bharat, and they had succeeded in Arunachal. I was quite surprised that they did, and I think it emboldened them. So the idea was to take one small state after another small state, and I think that bluff has now been called. And in this case, as Raju said, they really defied the court. In fact, they defied the court to strike down the presidential proclamation by saying, the court in fact asked if they could assure the court that they will not revoke President's rule, but they said, no, we can't give such a commitment. At this point, I think the court was left very little choice. And look, in this country, I have expressed a lot of disappointments with many orders of our higher courts lately. Also, frankly, I think time wasting over frivolous issues from IPL to Kohinoor to, if I may say,
Sikh jokes.
Well,
that was a petition.
Our Supreme Court was listening to a petition on Sikh jokes when Punjab government carried out this completely unconstitutional anarchist act of passing a law upturning God knows how many other laws.
That's right.
Before that, they had passed a law called Termination of Agreements Act.
Yeah.
Right? So in fact, when such a thing happened in Punjab, or when the riots took place in Haryana and Haryana police and state government disappeared, those were situations of complete constitutional breakdown where Article 356 use may have been justified. But to use Article 356 like this in a might is right manner, jiski lathi uski bhains, I think some court was going to stop it.
All right. I just want to go across to Abhishek Singhvi, who joins us for briefly on the program. He was the counsel in this case. Abhishek Singhvi, certainly you have reason to feel euphoric today, but as Soli Sarabji and others have rightly pointed out, the battle isn't over. You now face the test of the Supreme Court.
Absolutely. Everybody does. That's why there's a hierarchy of courts, and there's nothing to be euphoric about. It's just a feeling of satisfaction that we are proud in a vibrant democracy where the judiciary is the last resort for aggrieved citizens, and everybody has faith in the judiciary, and the last word in that is the Supreme Courts. I am confident that the Supreme Court, at least on final hearing, would affirm the judgment. That I am saying without being presumptuous. What it will do for the interim, we'll see tomorrow, but we are ready when it happens on a mention.
One of the important things you mentioned in your press conference today after the verdict was that the governor had never said in his report that there had been a failure of constitutional machinery and had never actually recommended President's rule. And this is important because one of the key things that this entire controversy centered on was what the governor's report actually said.
Nidhi, The problem is that when things are so hot and fast in this 24/7 world, law is forgotten and facts are forgotten. People don't know, and this was argued elaborately by me in the Uttarakhand High Court, that between 18th and 26th, a short period of hardly 8-9 days, 7-8 days, 8 reports in writing were sent by the governor discussing everything from the speaker's alleged partisan conduct to the alleged sting to the various other allegations which the central government was making. At the end of those 8 reports, 8 different times, the speaker did neither of two things. One, he never said there is a constitutional failure of constitutional machinery and the governance of the state cannot be carried on in accordance with the provision of the constitution, a condition precedent under 356. Second, he never said, therefore, I, the governor, recommend President's rule. After these 8 reports ending 26th, the central government sits in the night and 48 hours before the governor's recommendation of the 28th floor test suggests President's rule. Obviously, the governor didn't say it because he felt the best panacea is floor test. Bommai tells you in 20 paras that the best panacea for all ills is the floor test. In fact, Nidhi, it's very nice and interesting that the Bommai and the Rameshwar Prasad Bihar judgment says that when you have allegations of corruption, and remember Rameshwar had 1 month of allegations of corruption in horse trading, the best way to stop it is to have a floor test. On the contrary, the window provided by a President's rule will increase the horse trading. Now, forgetting all that, the central government puts a stop to it on 26th Saturday evening, 36 hours before the floor test. I mean, it's never happened in India that a double whammy is tried by the central government on 356. First, stop the effect of the governor's direction,
I
and second,
what you're
stop the
saying, but
disqualification proceeding of the
questions
speaker.
have also been raised on the speaker's conduct in all of this and the way this MLAs were disqualified. Yes. The questions have been raised about why, if there were legislators that had asked for a division when that money bill was being heard in the House, why that didn't happen and why a voice vote happened instead. There are questions that are also being raised on your side as well and on this about the speaker's conduct.
Nidhi, just understand this because it will be instructive. The appropriation bill not having been passed because the division was not granted was an argument which came from the political arena and was adopted lock, stock and barrel in the legal arguments by the law officers in Uttarakhand. Now just consider these admitted facts. Hello?
Yes, go ahead.
Hello? Can you hear me?
Yeah, we can. Go ahead.
Can you hear me? Yes. The entire edifice of the central government's argument was that 35 out of 68 people had asked for a division. The whole thing fell to the ground when it was pointed out that no more than 27 of the 68 asked in a written memorandum at 10:30 on 18th. At 7:30 p.m. in the evening, the vote was done. There was no written memorandum by the 9 defectors. At 11:30 that night, after the vote was over, the 9 plus the 27, 35 went in writing and said, "Oh, 4 hours ago we had asked." It was a retrospective wisdom by hindsight, but there is absolutely no evidence in writing. The 9 MLAs could have written a single line letter to the speaker. Nobody wrote. Secondly, and this is very important, Nidhi, assuming that the speaker decides to grant or not grant a division, that is entirely under the constitution in the speaker's domain within the floor of the house, and the judicial scrutiny is barred even by the Supreme Court under an article of the constitution called 212. To get over this, the central government made a bizarre argument. They said, yes, Supreme Court is barred from looking into speaker's conduct, but 356 central government is not barred. So what you will really have, if you accept this argument, Nidhi, is that the central government can sit with a pair of binoculars in Delhi, look at every speaker in a hostile state, a state which is a different political color, and the moment he makes an error on the rules of the assembly within the house,
they can
bang, the arrow is shot and you have a 356.
Well, then let me take what you have said to
Nalin
Kohli. To Nalin Kohli of the BJP, who has also been, back and forth in the court in this matter. Nalin, would you concede today that this is a setback and that the High Court's order is scathing and its observations are quite stinging?
Well, yes, I was there too, and I heard all the arguments, eloquent and otherwise. However, I'd say that I don't think anyone celebrates an order that goes against you. There's no question about it. And certainly anyone who does not have an order going in their favor is entitled to move to the next higher court. That's the hierarchy, as Dr. Singhvi just pointed out. However, let's look at it. Our point of view, which of course our Attorney General and the two additional Solicitor Generals, even Mr. Harish Salvi, who had come in on the last day, had put on is that everything hinges on the 18th. Now let's keep the argument focused only on that. 3 points I'm going to bring, and of course these might be part of debates further on, the proceedings further on. But one is that the issue that a division was asked for was denied by the petitioner, which is Harish Rawat, in his petition in para 16. However, on the final day, we were happy to note, almost satisfied, that Dr. Singhvi did acknowledge that 27 people from the BJP had asked for a division, which is what we've been saying consistently, which brings us on to the question of the role of the Speaker. Now, the court has said, as we've gathered, that the Speaker's decision is final. So I ask a question to myself, that if the Speaker in a house where 35 wanted a division is final, suppose this 35 was 45 out of 70, so is the Speaker final? Would he allow a money bill that has failed to continue? When tradition is that the money bill in the parliament, if it fails, the government goes. The same applies to the states. These are big questions. And that was the ground on which President's rule was primarily put.
But
the
ultimately,
failure
Nalin,
of the money bill.
The court has taken a very,
Sure.
it has taken a position on this. I'm asking you a political question and not a legal one. Politically, is this not a setback for the centre today?
I won't, concede that point because it's too premature to do so. Yes, the judgment hasn't gone in our favor. That's a fact. But whether you'll take it as a setback, why would we take that immediately? Because judgments come in favor and they don't come in favor. And many judgments get overturned at the next appellate court. So I think we should wait, not pass a comment immediately. I have one other point to raise, which is a larger point, and with Mr. Sorabji and of course Raju Ramachandran there, perhaps it might lead to some discussion. Even Mr. Moily, who's a former law minister, I am personally, I wonder whether it's correct in our constitutional scheme for courts to pass strong comments and make observations on things which are not yet in writing. Because judgments are meant to speak for themselves, not the observations, because they get open to then interpretation, comment, like we've seen in the headlines. President is not above law. Now, President is the highest authority in this land. There is a certain decorum, a certain constitutional distance that is there, but at the same time, should different institutions be interacting on a manner in making comments on each other? I wonder whether that is really the approach that we should really cherish.
All right, I think that's a very interesting point you raise, and I'll take that to Mr. Moily, who is of course the former Law Minister of India. Mr. Moily, before I get to the politics of it, the point that Nalin just raised about whether courts should be making observations on, for instance, on the president, the way that they have, or on other organs of government, as a principle, do you believe that that is something that is problematic?
That is the beauty of the concept of independence of judiciary. I don't think, that question of, we can question that kind of a wisdom of the court, whether it's the High Court or the Supreme Court. They ultimately, what my friend has said, just now, Mr. Kohli, that, the Speaker and also the Governor, they are, the constitutional authorities. One is not less nor another is more. It's very clear here that, yes, they came down very badly because of the argument of the Attorney General and other people across. Because when the arguments are advanced, very, very sharp arguments are done on behalf of the central government. Of course, on behalf of the state government, of course, it was with the Rawat. The question is, when the arguments are advanced and the matter is before the court, and of course, on that basis, they would have to pass a judgment. That shows that, that judgment is so clear, and, there is no ambiguity in anything. They clearly said, in the light of the Rajasthan judgment, the Bombay judgment, and also Rameshwar judgment of the Bihar, they said the invocation of the President's rule violates every line, every para, every spirit, and every philosophy of these judgments. So the Article 356 is the last resort. They took it first. And governor's recommendation also is very clear. It has been already told by my colleagues, Mr. Singhvi and others. Very clear that there is no such requirement or ingredients of the article for proclamation of Article 356. was not present at all in the recommendation of the governor.
Well, it's
And
interesting.
that where was the hurry?
I don't want to
That
remind
means
you
to
about
say,
how many
yes,
governments
I
Indira
did
Gandhi
it.
dismissed.
But Indira Gandhi's time,
No,
time,
that's a
time,
different-
time,
No, no, I know, I
That
know.
is why, those judgments,
Those are
those judgments have been there, no
pro-Mumbai
doubt,
times.
after the judgments are given.
Pre-Mumbai.
On
That's why the
Article
yeah.
356,
No, but you know,
see,
I
any
just-
government, central
I just
government,
have a-
whether it's our government or their
Shekhar
government,
Gupta has a question for you. Then
No,
I'll come to you.
I just-
adhere to those judgments. You cannot violate every line and having, this is a
Okay.
blatant violation.
Shekhar.
I just
Blatant
have-
violation.
I
I
don't
don't,
have-
think, of course, it is ultimately, it has to be, maybe can be agitated before the Supreme Court. But ultimately, the order of the judgment is, this is stored. And, they also raised, Attorney General or on behalf of the central government, the attorneys, they raised the issue that, this is a type, because of the political, he has a president, they invented a new theory of a political wisdom of the President of India to invoke Article 350.
No, these are all important points.
Well,
And
come in for
Shekhar
analysis.
just had an
I
intervention.
think
Nalin, one
in
second.
this
I'll just
case,
come
of
to you.
course, subject to the
I'll come to
judgment of
Nalin
the
in just a
Supreme
moment.
Court,
1 minute,
I
Mr.
think
Moily.
the
Mr. Moily,
Government
just
of
give me a
India
second.
owes an apology to the
Okay,
President
you're
of
asking
India
for an
having
apology.
misled
You're
him.
asking for an apology. Yeah.
I just have an aside as an observation that yes, courts should not be intemperate in the language they use, particularly about high authorities or people holding high office. But this is how things change. Just the other day, when the 2G bench was saying equally rude things, in fact, ruder things about Dr. Manmohan Singh, who was the Prime Minister, BJP was celebrating and Congress was complaining. Today, when this High Court has said something about the President and something about Government of India, the BJP is protesting and Congress is celebrating. So I think there is a distribution of powers in India. The reason judges are using this language and the reason judges feel free to use this language is because the political class and the executive now across two sides of the divide treat each other as enemies. They have no commitment to the institution of the executive or the institution of parliament. And that's why I think they expose themselves to this kind of public reprimand. Frankly, I would have liked someone from the BJP while the 2G case was going on to say, how can the Supreme Court judge say, we are getting angry?